Welcome, everyone. Welcome to the Veterans Chamber of Commerce Legal Tuesdays. We're here with Kelly. Kelly is a local attorney in California and one of the best attorneys I know. She breaks down the law nicely for those of us who are not uh, legal savvy. So I came across uh, to Kelly through our LinkedIn and through a magazine that we both write for. And so I approached Kelly with some questions, and she was just amazing on how she responded. I was able to get my answers right away. So then we decided to, why don't we bring this information to the public so they also know Kelly and they can also get their answers, their questions answered. So welcome, Kelly. Welcome to our show today. It is always a pleasure.
Thank you, Joe. It's always fantastic being here.
And I know you have a disclaimer for us.
Absolutely, yes, as all attorneys should. So, the information that I'm sharing today on this episode of Legal Tuesdays is only information purposes, and that is it. It does not create a client attorney relationship.
Well, thank you. And we want to make clear with that. So today we wanted to ask you a few questions that I have come across through the social media channels and platforms of people asking the same question over and over and having that uncertainty of what to do. A lot of business owners, we are eager to start our business. We have our idea of how to start the business. We move forward, and whether we contract with an attorney or we go online and just register with one of those platforms, and then we're like, voila, we are now we have a corporation, now we have an LLC, but uh, that brings, based on our previous conversations, that brings a list, a laundry list of things that as a business owners, we're obligated to do legally, which, many of us, we not really familiar with. So I wanted to ask you, so once someone registers a corporation, let's say a corporation or LLC, if there's different, please let me know. Raise a corporation or an LLC, but it's California somewhere else, but in this case, let's say California. What's next?
Joe, I'm so excited that you brought this particular question up because out of the top five things that can literally take down a corporation or a business very, very quickly from the legal standpoint, this is probably number four. It's rated up there. People get very misconfused. Well, they get confused or there's misinformation. So when one registers their business with the state of California, that doesn't mean that they are protected going forward forever now. They actually have to follow corporate compliance. And what that means is, so for example, in California, California law says we're happy to provide you with that limited liability protection. So when you do get sued, someone can only sue your corporation or your LLC and not you personally. That's usually the number one reason why people need to incorporate is to protect their personal assets. Now, just by filing again doesn't do that. You still have a laundry list of items that you have to upkeep every year. So once you filed with the state, fantastic. You actually have to file a statement of information once a year with the state of California. And that's usually an online document that you fill out. The fee for that is $25 if you're a corporation or $20 if you're an LLC. And it's simply a statement of information. The state wants to keep your information current in case someone is looking for you. That's number one. Number two is you obviously must pay your franchise tax. Right? You have to pay your franchise tax.
Of course.
Exactly. California, they want their money somehow. And if you do not pay your franchise tax, usually it's about $800. It can range, it can go up to even $1,000, depending on how much money you bring in. But it's usually about $800 that goes to the state every year. So now you're up to $825, right? And it doesn't really matter whether you're a corporation or LLC, the franchise tax is exactly the same. So you have to maintain your good standing with the state. If you become delinquent on any of these filings, and again, it's once a year with the state, if you become delinquent, the state will suspend your business, which means that you are no longer in good standing, which means that if somebody sues you during that period of time, they can sue you personally, Joe, personally. So now you because of either you didn't know you had to do this, or there was an oversight, you opened up the gate now to let anybody come in to sue you personally for your personal assets. So those are two biggies that every company must comply with. If you're a corporation, you have to keep the bare minimum that you should do is to keep your annual minutes. And what those entail is you have one set of minutes from the shareholders. So the shareholder elects the directors. That's one set of minutes. The second set of minutes is the directors appoint the officers. And this is in compliance with the corporations law. And you have to have, that's the bare minimum. If you're a corporation, absolutely, you can meet once a month, you can meet once a week, as long as you are keeping minutes. You can even just write the minutes down, just basic information, the day, the time, who was present at the meeting, what was discussed and what was approved. Just simple little things like that. You don't have to follow some elaborate outline.
Okay.
Yes, and that shows the state that you are actually keeping your business separate from yourself, because when you meet with yourself as an individual, you don't write minutes, right?
Right.
you don't say, oh, I'm going to go shopping today and I found this fantastic purse and I bought it, right? But you have to do that for your corporation.
And that brings a really good question, and it's kind of side note question. If you are a sole owner of a corporation, or actually in California, you got to have at least two people, but how do you meet with, well, actually in California, you can just be yourself, correct?
Exactly.
Okay. So how would you waive that so you don't have meetings with yourself and you end up talking to yourself about stuff?
If you're a corporation, there's no getting around that. You have to have a meeting and just write those meeting notes down. You have to do that bare minimum. If you are an LLC, Joe, the LLC, the members are not required to have annual minutes. So it does bring down the compliance part a little bit for an LLC. Okay. But if you are a corporation, there's no getting around it, because if the day comes and you are sued, opposing counsel is going to say, well, show me your corporate documents. Show me that you treated the corporation separate from yourself. And you should say, how many years back do you want? Here you go. These are all of our minutes, right? So that's the position you need to be in.
Okay. Very good. Very good. Thank you. And I know you mentioned the statement of information, and that, when does it have to be filed?
The statement of information, I always make sure that my clients have scheduled the date. And I like to always take the date of incorporation. Always take the date of incorporation, the date that your paperwork was filed. Mm-hmm. And then put that on your phone as a reminder, set for every year. Just automatically it will pop up and say, file your statement of information. It's always on that date, just to be on the safe side. But if you're a brand new corporation and you just filed your articles, then you have about 3 months before you can file your statement of information.
Okay. But you will suggest just every year, same day when you register, that was always in your mind.
Absolutely. And then throughout the year, Joe, if your business address has changed, don't wait until at the end of the year, or the year that I suppose the month that you initially filed your paperwork. You need to file any major changes, such as a business address change, such as a officer change, such as a director change, and even your agent for service of process, if any of those change, you have to file a new statement of information.
Okay. And you mentioned something right now about the agent of service. Is that a requirement um, when you have a corporation or an LLC, is to have an agent of service?
It's required for both. You cannot have a corporation or an LLC without an agent.
Okay.
Yes.
And the good question here is that, can you be your own agent of service?
Absolutely. So as long as you live in the state of California, you can be your own agent. But I usually discourage people to be their own agents. The reason being is because an agent for service of process is the first person that someone's going to contact if they want to serve you papers.
Okay.
If they see an attorney's name there to be your agent, then they're going to think twice. But if it's just you, then they can get to you directly. And I always act as the agent for service of process for all of my clients.
Okay. And that's very smart, because you're totally right. I mean, I experienced that before. If I make a phone call myself, or I mean, people tend to like not really take you as seriously because you're just the owner. But when any moment that I say, well, you know, you talk to my attorney, blah blah blah, and then all of a sudden they start kind of taking a step back and not be so bullying, if you will.
Exactly.
With you. Okay. Now, when you're talking about the agent of service, what is the cost for something like that?
Well, I always, it's a complimentary service that I provide my clients. But usually, if you're going to pick another third party, it can range from about $70 to about $150.
For the year?
Yes, for the year.
Okay. All right. Very good. That's great information. Thank
Yes.
you. So now the corporation has been formed. The statement of information has been submitted. The corporation or the LLC has an agent of service, and preferably someone like you, so they're more protected. And preferably they form the corporation with you, so they know they're doing things correctly.
Right.
So now they get their stuff. And I want to take a step and say that, you know, in the used to be that some entities will provide people with binders and things like that, and seals and things. And I would like to, for my personal, and maybe you want to confirm this, but I feel that those are not necessary, correct?
They're not necessary. You're absolutely right. They're not necessary. But it's a nice way to keep everything organized, especially when you are a brand new company. Plus, some of these binders, they should come with stock certificates as well.
Which that leads me into the next.
Beautifully set up, Joe.
You're welcome. So now I'm set up. I got the binder. Let's say you're from our corporation. You give me the binder. And then I see share certificates or stock certificates. And I have people that I may want to provide those to because they may want to invest in the company. And I'm just, how do I do that? Just write the checks, write their numbers, take their money. What's the process?
I wish it was that simple. If it was that simple, people wouldn't need attorneys, right, Joe?
Correct.
Actually, this is a really, really important topic, and maybe we could do another segment on it because it's that important.
Okay.
Now, issuing stock, it falls under the branch of the SEC, which is the Securities Exchange Commission, SEC. That is a branch of the government, and they oversee all types of issuance of stock. And if you do not fall under an exemption, or you do not file with the SEC as a corporation before you issue stock, that act in itself, it's a criminal offense.
Really?
It's criminal offense, yes. Absolutely.
Ouch.
So exactly. The owner of the company can literally go to jail for this for an extended period of time. Plus, they're going to pay a fine on top of this too. Now, the SEC, the small business owners, they said this is what do we need to do in order for us to issue stock? So the SEC said, well, you have to register with us, and registering your company with the SEC is literally as if you're doing a mini IPO. We all know how expensive IPOs are,
Oui.
extremely expensive. The bare minimum, you're probably looking at $50,000. That's just the bare minimum. So the small business owner said, there's no way that we can file with you. It's too expensive. So that's when the SEC came out with exemptions.
Mm.
If you fall under an exemption, you do not have to file. But how do you capture that you fall under an exemption? That's where you have the shareholder agreement that comes into play with the SEC rules and regulations in there as to how long do you have to hold the stock before you turn around and sell it. The government didn't make all of this up just to make our lives harder, right? At some point they do. The government does create things to make our life hard, but this in particular, they didn't. The reason being is because people can actually buy stock and sell it just like that. This is a private company, right? So they're trying to prevent the crash, if you will, the big hikes in the stock market. So there are rules as to how long someone has to hold the stock before they're eligible to sell it. If you are a private company, which I'm assuming, most of our wonderful listeners are and wonderful members are, you're a private company. You do not want to see after a certain amount of time that you issued stock to someone that they're going to go out and sell it to whoever you want. Now you're holding your company with some stranger that has no business or no purpose in your business, right? So that would be a nightmare for any small business to experience. So in this shareholder agreement, there are going to be clauses in there as to if you're going to sell the stock, who do you sell it to? When can you sell the stock? First right of refusals for the company or the existing shareholders, the exemptions for the SEC ruling, because without this agreement, Joe, if the company is audited, they have to pay a fine because they've issued stock without the agreement, and or the owner is going to go to jail.
Ouch.
Yes.
Okay.
So you can't just, someone can't just write you a check and you give them stock. There has to be a process through it. You have to have a shareholder agreement with all of the terms and conditions in it before you take the check and cash it.
Okay. Good point. And you mentioned something about exceptions. What are those? Can you give me some idea what those exemptions are?
Yes, the exemption. So there are different sections of the SEC Act, right? The Securities Act. You have a Securities Act of 34 and Securities Act of 35. And it's a big, massive book, and I'm sure nobody wants to read it.
I'm sure
So
it is.
exactly. And so in there, usually some of these exemptions are, if you're issuing stock for personal, right, to someone personal, not for gaining an advantage. So you don't issue stock to 10 people and then those 10 people go out and share their stock with another 10 people. So you can't do certain things like that. There are restrictions for stockholders or shareholders to be US citizens, right? Cannot be foreigners holding the stock, especially for an S corporation. That applies to an S corporation.
Okay.
And then if there are foreigners holding stock, which they can in a C corporation, then there's another section there that says, okay, if they are foreigners, then they can't do X, Y, and Z. The exemptions, the other exemption is the holding period as well. The holding period can be from 1 to 3 years before you can actually, you're allowed to sell the stock. And then again, personal gain, you're not buying the stock so you can resell it again. So if any of these are violated, then there's going to be huge fines to pay. Okay. And it's up to the owner. It's up to the owner of the company to make sure that these are not violated.
Okay. So, and this process, which I think next segment, will go into issuing stock, and then you can just walk us through the process so it's clear. So I know it sounds like it's convoluted, but also massive amount of do's and don'ts.
Absolutely.
And I think our listeners, our entrepreneurs will benefit by having at least the basic information and also the ability to contact you for questions and on how to do it or to get your advice on that.
Absolutely. There's been quite a bit of chatter, if you will, in the news where there's been securities fraud, right? So
Mm-hmm.
this is what, when they refer to securities fraud, this is exactly what they're referring to: the issuance of stock, which was done fraudulently or not in compliant with the SEC rules and regulations.
Okay. And especially for corporations, I mean, I know LLCs don't have this issue because they can just issue percentages. But in a corporation issuing stock, that means people are gaining ownership of the company, and then and having the ability to. That also creates a risk on my, if I'm correct. So someone can just basically buy you out, right?
Exactly, Joe. So that's why it's so important. And I counsel my clients, the ones that are starting out, they're so excited about it, and they should be, right? It's a brand new venture. They're so excited. They're going to go into business with their high school friends, right? And that they've known from high school, and they've
Oops.
all come together and they've, created this brilliant idea. And then it's like, oh yeah, issue so-and-so stock, issue so-and-so. And all of these little parts of stock are just issued to everyone.
Right.
Well, you should never, ever do that. You should always look at the big picture, because if you're a company who's looking for private funding, you're trying to raise capital, you're trying to raise money from investors. Well, the investors are going to say, well, show me who else is an owner of your company. And then they're going to list these 15 people. That's a huge turnout for an investor. They don't want to see, multiple little shares issued to a lot of people, especially family and friends, and so there's a way to structure the issuance of stock. And yes, I would be happy to address all of these in the next segment that we do on issuance of stock.
Well, excellent, because we're almost running out of time. That's it. And I know there is also the issue of the share value, and when the company starts, there is how to split the shares so the shares can be split and double split and all that kind of thing. Then I'm sure you know a lot about, and I do not. So
Right.
so and that would be great for our entrepreneurs and friends to know. When you get the shares, they usually ask you for, like, people say, well, just put a dime in, or a penny, or a dollar, or 10,000, and all those tricky questions are what I call blind spots in business, because you just act on those and then it comes back and bite you later, because that was a blind spot that you just did not expect. So I'm very thankful for your time and your information, Kelly.
Absolutely,
And,
Joe.
and
And
you can just please let us know how can we, our listeners, contact you directly, and you can just give us your and I'm going to post that on the video also. But if you can just let us know what are the best way for us or for our audience to get in touch with you.
they can email me directly, kelly@baglerlaw.com, or they can absolutely phone me. It's 760-784-9109. That's my office number. And if
Okay.
they would like, they can certainly call me on my cell number too, which is 760-525-4540.
Okay.
Thank you.
Well, thank you, Kelly. I really appreciate it. This information is invaluable, and it will, I'm sure, it will help a lot of people stay out of trouble. And and you're totally right. When we start a business, we are so excited about doing things, and we ask people, we ask around, and we ask other people, what have you done this? What have you done that? And we start kind of relating, what they done or not done, but not necessarily getting the right information.
Right.
So you give us the right information. You tell us what the path to follow and what is the best way to start the business. and to be ready for potential growth.
Absolutely.
So I'm very thankful, very grateful that you're willing to do this for us. And we thank you and look forward to our next segment, which will be talking about issuing stock and what it takes to issue the shares and all the good stuff.
Fantastic. Thank you so much, Joe.
Well, thank you, Kelly. Really appreciate it.